Are you seriously going to stand here and talk like that?
No, ma'am. I didn't mean to. I'm terrified. I'm so sorry, ma'am.
Just don't do it. I don't know why they don't listen. It took me aback. I was not expecting that at all. What? Like everybody makes my mama stuff come out. I hate it. All right, are you Koshma Thomas?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
He will, Your Honor.
Judge, with the court's permission, we're going to abandon 5, 6, and 7. It's my understanding that those cases have been dismissed.
Okay, thank you, Ms. Malfino. Mr. Thomas, in cause number 23, DCCR 0935, I have a motion to revoke your community supervision. It shows that you were placed on probation October 17th of 2023 for the offense of evading arrest or detention with a previous conviction. That was a 2-year state jail felony term that was probated for 5 years. Is that correct?
Yes.
Okay. It's a first amended motion to revoke the community supervision. It alleges in count 1 that you violated your probation by failing to report to the probation office as directed May 22nd, June 26th, July 17th of 2024. And is that true or not true?
True.
Count 2 alleges that you provided a urine sample March 18th of 2024 that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
Count 3 alleges that you failed to pay your court-assessed fees as directed, and as of July 17th, 2024, you were behind $820. Is that true or not true?
True.
Count 4 alleges that you were arrested for the offense of evading arrest or detention with a vehicle February 5th of 2025 in County, Houston. Is it Harris County?
It's Houston County.
Is it Houston County? Okay, so not Harris, it's Houston County. Is that true or not true?
True.
And then the state abandons 5, 6, and 7. Count 8 alleges that you failed to remain in Jefferson County as directed and that you were in Houston County February 5th of 2025 without permission. Is that true or not true?
True.
And then count 9 alleges that you possessed a drug, marijuana, on February 5th of 2025 in Houston County, Texas. Is that true or not true? Did you enter your pleas of true to counts 1, 2, 3, 4, 8, and 9 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objections.
It's admitted. Is there any evidence that Mr. Thomas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of true to counts 1, 2, 3, 4, 8, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. I went over that with you when you entered your plea at the first hearing because you were convicted, but I do want to make sure you read it and understand that because you are convicted of that offense, you're not eligible to possess a firearm in Texas, okay?
Yes, ma'am.
All right, you're free to go. Back with the bailiff. Thank you, sir. Is there a Mr. Zuniga here? Okay, so Ms. Williford, in cause number 24, DCCR 1720, I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation December 3rd of 2024 for the second-degree felony offense of aggravated assault with a deadly weapon, and that was a 5-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that...
We've agreed to go counts 3, 4, 7, and 8.
Thank you. 3, 4, 7, 8. Count 3 alleges that you provided a urine sample August 14th of 2025 that tested positive for tetrahydrocannabinol. Is that true or not true?
Yes.
True or not true? Count 4 alleges that you provided a urine sample September 18th of 2025 that also tested positive for tetrahydrocannabinol. Is that true or not true? Count 7 alleges that you failed to provide verification of entering and successfully completing the anger management program. Is that true or not true?
Sure.
And then count 8 alleges that you are behind in your court-assessed fees as of September 18th, 2025 in the amount of $688. And is that true or not true? Did you enter your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily? And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them?
Yes.
And do you understand if I follow this agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
Speak up, please.
Yes, ma'am.
And it looks like the agreement that you've reached is to remain on probation, but enter and successfully complete the special needs SAFE-P program. Is that your understanding?
Yes, ma'am.
And we've got probation here with us today, and is that the recommendation from probation as well?
Yes.
Okay. I am inclined, if I follow this agreement, to extend the probation by some amount of time, just based on the allegations and the time that'll be spent there. So I want to make sure there's plenty of time after that she has still on probation. State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Williford is not competent?
There we go.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 3, 4, 7, and 8 freely and voluntarily. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that today. Looks like there's some, everybody's willing to work with you, but I want to make sure you understand that we're going to send you to the special needs SAFE-P program as a condition of your probation. I'm going to extend your probation by 1 year, and this is going to be, hopefully, listen carefully to what I'm saying, okay? Because this is the second chance you're being given, and there will not be a third. So you need to take advantage of every opportunity that is being given to you. You're going to get help with drug abuse. You're going to get help with mental health, with everything you need to be successful when you get out of SAFE-P. If at that point you don't follow through and do what you're supposed to do, you're going to be back in here and you're going to be looking at going to prison for up to 20 years. You understand? You okay? Are you okay? You're getting white. She's getting white.
I had a statement prepared for you, explaining the only reason I was doing marijuana at the time was because of my cancer, my pain management for cancer. And I will promise you on Jesus' happy golden good soul that I will never touch this shit again if you let me go home.
Are you seriously going to stand here and talk like that?
No, ma'am, I didn't mean to. I'm terrified. I'm so sorry, ma'am. I just didn't realize how much trouble I'll get into.
You're on probation for a second-degree felony, an aggravated assault with a deadly weapon.
Yes, ma'am. I realize that. I was trying to...
There's all kinds of other ways to deal with issues, and there's definitely more respectful ways to speak to the person who could put you in prison for up to 20 years. I don't have to go along with this plea agreement right now.
I'm so sorry.
Okay. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. Go back with the bailiff. Good morning, you're Ryan Biones.
Yes, ma'am.
And Mr. Biones was previously in court, entered pleas of guilty in cause numbers 25 DCCR 1106 and 1108 to the first-degree felony offenses of aggravated robbery. The agreements were for 10-year deferred probation and $500 fine in each. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor.
I have, Your Honor.
Are there any additions or corrections?
Not from the defense.
No, Your Honor.
So, obviously, Mr. Biones, this gives me a lot of concern based on the nature of these offenses. Another thing that I make notes in your pre-sentence report, and one of the things that I have found continuously happening in cases with young people your age, you're 18? Okay, so everybody says they're hanging out with the wrong crowd, right? But everybody can't be hanging out with the wrong crowd. You've become the wrong crowd, right? And so if I give you this opportunity today, then this is the best opportunity you will probably ever get in your lifetime, because you will be able to live your life, hopefully, in a very different way than you were on that night, and the way you were starting going down that road as a juvenile with stealing cars, right? Why didn't you finish school?
Because I kept getting $6 and I can't.
Because you kept getting in trouble, right? So part of your probation is going to be that you get your GED, and you're going to get it soon, because that's hopefully you should want to get that, because it's going to help you be more successful in life, but it's going to be a part of your probation. You understand?
I'm in the program already, it's just waiting on me to go.
Okay. And I know that ISF Cognitive was not a part of this plea agreement, but that is what's going to happen today as well, and I'll explain that more. I'm going to find, Mr. Biones, that you entered your pleas of guilty in each of your cases freely and voluntarily. Find sufficient evidence to find you guilty. In cause number 25 DCCR 1106, follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, and I'm going to go over some of those in just a minute. And cause number 25 DCCR 1108, also find sufficient evidence to find you guilty, but follow the agreement and defer all proceedings and place you on probation for 10 years. You're also ordered to pay the $500 fine and to follow all of the rules and conditions of probation. One of those conditions in each of your cases is that you will enter and successfully complete the cognitive track of the ISF program. That is a 90-day program. That is, you'll go from jail to that program. And it is a program where you receive tools to help you make better decisions. You're young, you're going to have to be making very adult decisions if you're going to keep yourself out of prison, and that's going to help you do that. So what that means is, if I give you that up front and those tools up front, and then you get out and you violate your probation, there's no coming back and saying, oh, I need a second chance. This is that chance, you understand? Also, a condition of your probation is that you have no contact with Deshaun Vital, or Vital, however you say his name, the co-defendant. Obviously, you have no contact with the victims, Leandre Collins and Peyton Mahan, and you're not allowed to possess a firearm at all. Even though you're not convicted, you are not allowed to be in possession of a firearm. That means in the house you live in. So if you live in a home and other people have guns, they have to have them either locked down or out of the house, and probation can come check on that and make sure of it. And if you're caught where there's a place where there's guns, that's a violation of your probation. Can't be in a car with them. You can't have them anywhere. You understand? And so if you do everything that you're supposed to on this probation, again, this is an excellent opportunity, because you don't have the felony convictions on your record. And you will be able to, at the end of the probation, if you're successful, have these cases dismissed, and you'll never be a convicted felon. The other side of that, though, is if you violate any condition of probation, you're brought back in here found guilty, so you're then a convicted felon, and I can sentence you to prison anywhere in the range of punishment, which is up to, I think first or second?
It's the first year.
So it's up to the rest of your life. It's between 5 years minimum in prison, up to the rest of your life in prison. That's what's hanging over your head. So you have to grow up very quickly and make good decisions like everybody else that's not in prison, or else you'll end up there. You understand? I'm handing you the trial court certifications in each of your cases that shows that these were agreements that I followed, and so you've waived your right to appeal, and so you can go back with the bailiff. All right, good luck to you, sir. Good morning. Are you Burton Edward Bailey?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He will, excuse me, he will, Your Honor.
Mr. Bailey, in cause number 25 DCCR 1380, you're charged with the state jail felony offense of theft of property with previous convictions, and that's from August 9th of 2025. The indictment alleges you were previously convicted of theft May 13th of 1991, and then again January 11th of 2024, and then August 29th of 2024. And then it further alleges that you were convicted of possession of a controlled substance, a state jail felony, October 2nd of 2008. And after that was final, convicted of possession of a controlled substance, a state jail felony, October 26th of 2011. Convicted of delivery of a controlled substance, a state jail felony, May 11th of 2012. Convicted of possession of a controlled substance, a state jail felony, October 5th of 2018. And then convicted of possession of a controlled substance, a state jail felony, July 31st of 2024. And how do you plead to that charge?
True.
Well, are you guilty or not guilty of the theft?
Guilty.
Okay, and are all of those prior convictions true that I read out?
Yes.
All right, did you enter your plea of guilty and true freely and voluntarily?
Yes, ma'am.
And did you plead guilty and true because you actually did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes.
Do you fully understand them?
Yes.
I need to know what some of those prior punishments were. I feel like this is incredibly low for that amount of criminal history.
I'll let you know, Judge, that we took into account, prior with it. That's right.
Okay,
That in the federal case is the only substantial time he's got.
okay. All right, Mr. Bailey, do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Any evidence that Mr. Bailey is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of the state jail felony offense of evading arrest with previous convictions. Find all of those prior offenses true. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. Thank you. Thank you, Mr. Coleman, Mr. Rojas.